It is March 27th, 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today's compilation is another absolute roller coaster. We're watching Judge Simpson hand down a massive $500,000 bond for a very good reason. We also have some familiar characters returning to Judge Simpson's courtroom, including one in a burqa arguing over escrow money. In Texas, a familiar defendant is before Judge Stevens to learn her fate after attacking police officers and running from the law. Those 9 convictions don't help at all. And stick around for the finale. A petty art apartment feud gets so out of hand that the local police chief actually takes the stand to explain countless 911 calls over kids playing board games. Grab your lucky dice, get a drink, and buckle up. It all starts right now.
Redford West versus Mary Cheatham.
Good morning to you, Judge Simpson. This is Attorney Paul Spaniello. My P number is 72366, and I'm here on behalf of the plaintiff in this matter.
All right. Mary Cheatham?
I'm here, Your Honor. I'm trying to put my camera on.
Gotcha. Okay, what? Did we get her? Nope. All right. While you do that, counsel, this is a non-payment of rent case. What's the plaintiff's claim, including cost?
The amount, including cost, is $6,158.00. That's January through March with court costs.
All right. And Ms. Cheatham, we've got a picture now, and if you can unmute.
Okay.
Okay, there you go. All right. How are you intending on trying to get this paid?
Okay, so this is the deal. I've spoken with Ms. Shifter because this has been kind of a complicated process. It was a possession case. I don't know if you remember. I was in here maybe a few weeks ago. It was initially a foreclosure, and then I had signed a lease. And speaking with Ms. Shifter, my intent is to vacate, and there was some discussion about possibly avoiding a judgment. I have reached out. I have some help coming my way through a place called Here to Help organization. They help people that were encouraged with funding for new places. Basically, my intent is to vacate. I was waiting for my inheritance to come through because the thing, I have the money to pay the back rent. And if I do that, then I don't have money to move. And I don't think that they want me to maintain or remain in the lease is the thing. So they just want the property to vacate.
Okay. So if I adjourn this out a couple of weeks, you guys think you can get that all solved, or?
I think so, because my intentions are to be later the 15th. It'll probably be sooner than that, but
Judge?
Counsel?
Thank you. If nothing else, I'd like to make a record. Your Honor, you may or may not recall, we filed this case late last year as a termination subsequent to the expiration of the redemption rights. We did a termination. You dismissed the case because my client executed a lease because Ms. Cheatham advised that she wanted to stay in the house. She tendered a payment, which subsequently was reversed as NSF charges. The court advised the parties that this had to come in another manner. So we filed a non-payment case. Respectfully, this story about moving out has been going on since, I don't know, late quarter of 2025. So I frankly find that this explanation is intellectually just disingenuous, Your Honor. So if Ms. Cheatham was going to move, I mean, we've been asking since late last year when the termination was filed. And then when the payment was made when the lease was executed and was reversed, it was clear that she wasn't going to stay there. So and Ms. Shifter has not advised me, or my client has not advised me of any agreement whatsoever. None. Zero. That's why we're back here, Judge. So
who, Ms. Schichter, help me, who is that with reference to these parties?
She's a representative of the client, of the plaintiff. She was here. We came in an in-person hearing that resulted in a default judgment. I can't remember the exact day. If it's of any importance to you, I can find it. But we got a default judgment. Ms. Cheatham filed a motion to set aside the default. You granted that.
No, I recall.
Okay, I'm sorry. I don't need to go.
No, it's okay.
Thank you.
It's okay. No, I recall because it was certainly an unusual circumstance.
My client made an error. No good. This is classic. No good deed goes unpunished. There was a lease executed. Ms. Cheatham advised that she wanted to stay in the property. It was her family's property. My client did that. They signed the lease. Guess what? The payment was reversed, but the court felt, well, counsel, your client has a landlord-tenant relationship now. Well, here we are. Yeah. January's not been paid. February's not been paid. March has not been paid. And now we're being told, oh, we need time to move.
Well, here's the thing. It's now filed as a non-payment of rent type of case. If the parties can't work it out, but she would be entitled to an adjournment of the proceedings. How much is monthly rent on this?
Monthly rent is $1,900.00, Judge.
1,900?
Yes, 1,900.
May I respond to Mr. Is it Spaniolo? I spoke with Ms. Shifter, I believe, on the phone. It was I think it was the Friday before last. And I advised her that I was trying to get into contact with my lawyer to get a definitive timeline of when my inheritance might be coming through. But that's neither here nor there. My intention in the first place was to stay in the house. And unfortunate things happened. And I don't know if you remember. It's neither here nor there. The money, I had it, and then something happened, and it was gone. So at that point,
all right. Here's what I'm going to do. I'm going to reserve the issue of escrow because I can't order it at this. She would be entitled to an adjournment in any event, this being a non-payment of rent case. I don't have a week out. I do have 2 weeks out. So I will adjourn this to April 10th, 2026 at 2 p.m. That is an in-person hearing. And given everything, I think I'm going to want all the parties.
Understand that. Forgive me, Your Honor. You said April 10th, correct?
Yes, April 10th, sir.
At 2 p.m. Thank you, Your Honor.
Thank you.
Have a good day.
You do, sir.
Thank you.
Joseph Getz versus Joshua West.
Morning, Your Honor.
Okay. Mr. West, I'd appreciate you not smoking.
Yeah, no, I'm not.
Okay. All right. Mr. Getz?
Yes, Your Honor.
What is your claim in this case?
So he hasn't been paying rent for the last 2 months. We're approaching a third month without him paying rent. I tried to serve a notice to vacate on the first month, and I didn't use the right paperwork, so I served a 7-day notice to quit.
Okay. So, sir, how much does he owe?
At this current moment, $1,400.
All right. Then you've got costs, it looks like here, of about 87. All right. Sir? Mr. West?
Yes. Yeah.
How are you intending on getting this paid?
Well, what happened was when I moved here, I didn't have any money. And I've known this guy since like first grade. He told me it was cool. And I got 2 jobs and I started paying the rent. And the rent there was never any lease signed or anything. I never got, but the deal was that when I started working, it was like, I'll give you the money when I get paid. And in January, I paid him on the 23rd. And then in February, he got all drunk and started freaking out and told me he was going to throw all my stuff out and started putting my stuff in boxes and throwing my food away. That's why I didn't pay the rent. And I would have moved out if I had anywhere else to go, but
All
I
right.
don't have anywhere else to go. So
Do you
I'm
have, this is a non-payment case, so do you have the money to pay?
no, not now. I don't.
Okay.
Yeah, I moved in here and this guy told me he was on felony probation and he wasn't drinking, and then he's drunk every day going crazy, and I ended up getting fired because I didn't sleep for a week dealing with this. Like
Okay.
it wasn't like I just didn't pay the rent. Like I'm trying to get it
All
together
right,
and get
here's
out of
what I'm gonna
here.
do. Second service wasn't paid for. What I'm gonna
I
suggest
don't know
that you
I don't know what
accumulate,
that means. I don't know what
well,
that means.
there's not a second service by the court, which means I can't take a default or do anything today. I'm gonna adjourn this out. Mr. West, if you think that you need an attorney, and for that matter, Mr. Guest, if you think you need an attorney, that'd be your opportunity to hire an attorney. We'll adjourn this out to February to April 10th, 2026 at 2 p.m. That's an
2 p.m.
in-person hearing, and I'll need you both down here at the courthouse. All
You
right,
said April
Mr.
10th.
West, April 10th, 2 p.m. Mr. West,
Okay.
in the interim, what I'd suggest you do is accumulate what funds you can when you come down, because I think Mr. Getz is probably correct. Another month is going to click in by the time you get back here. And so there's going to need to at least be a payment while you guys try to work this out. All right.
I would pay it if I had the money. I don't have the money. It's not that I wouldn't pay it. I've been trying to find a job.
I hear you. What I'm indicating, though, is that you said you had jobs.
Not
So,
anymore. Not anymore. All my
because you got fired.
yeah.
Okay. Well, okay. So we'll see you guys down here April 10th, 2 p.m.
Thank you,
in
Your
person.
Honor.
Okay.
All right.
Do
Thank
I have
you.
to do anything else right now, or?
Well, if you want to hire an attorney, you can, or if you want to seek assistance, you can call the numbers that were on the slideshow at the very beginning. You can call
Okay.
Hawk. Did you get that number?
No.
All right, you
saw.
got some. Do you have something to write with?
Hold on one second. I do. Okay.
That's area code 734.
734.
Yes, sir.
And what was it called again?
It's called HAWC. That's an acronym. It's HAWC. Housing Access for Washtenaw County.
Okay, and you said April 10th at 2 p.m.?
Yes, sir. In person.
Is that just Saline Courthouse, or like to get
No,
directions?
you're gonna come to the courthouse I'm at, which is the one by the sheriff's department.
What sheriff's department? In Saline?
Washington.
Or?
No. All right.
I just moved here in October. I'm not from. I don't know
Okay,
where
no, I got you. I'm just
I'm
trying to
not
explain
trying
it
to.
to you.
Yeah, I'm not trying to
No,
give you a hard time.
sir, I'm just trying to tell you how to get here.
Okay.
The address is 4133 Washtenaw Avenue.
Okay.
Okay, and it's right off of US 23.
Okay.
All right. So if you were to just ask or put in your phone the Washtenaw County Sheriff's Department, it'll show you this location. We're right attached with them.
Okay. Well, if I don't get some money, my phone's gonna get turned off. Can I still show up and do this without my phone?
Oh yeah, you can show
Okay.
up. I
Okay.
was just saying, use your phone to find the location.
Yeah. Yeah.
Okay.
Okay. Yeah.
All right. We'll see everybody April 10th.
Thank you, Your
What?
Honor.
Okay. Thank you.
All right. Thank you.
Do I just
That's
hang
it.
up now?
Yep. Hang up.
Okay. Okay.
You're
Thank
good.
you. Thank
All
you.
right. Okay. Court's in recess. Court does call the case People versus Latanya Lang. Is this an arraignment?
Yes, Your Honor, Kristen Lewis Perez requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Chief Assistant Prosecuting Attorney Victoria Burton Harris.
We're actually going to let you do things.
Mm-hmm.
Okay. All right. Permission to practice is granted.
Wanted to see more of me, so we made it happen.
I did say that. So
Did.
I'm glad. All right. Ms. Link?
Yes.
All right. Ms. Link, you are before the court on a felony complaint that alleges that on or about January 1st, 2026, at the location of 725 Manor in the city of Ypsilanti, Washtenaw County, state of Michigan, that you did make an assault upon a Kaylin Lowe by strangulation and or suffocation. Do you understand the nature of that charge, ma'am?
Yes.
All right. That's a felony punishable by up to 10 years, up to a $5,000 fine plus court costs. Do you understand that?
Yes.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, I do.
All right. This is a public defender case.
Good afternoon, Your Honor. First Assistant Public Defender Queen Anderson. Your Honor, we met with Ms. Link this morning and she declined counsel, so we did not have an opportunity to speak with her. If Your Honor would allow Ms. Van Blarken to have a moment to speak with her in a breakout room, please.
You want me to give a breakout room?
Yes, please.
Have I ever done that? Fine, Anderson. You know she'd ask. I'm gonna do that. All right, ma'am.
Yes.
Their attorneys came to speak with you earlier today, and you declined to talk to them.
Yes, I did. Yes. Yes, I did.
Okay,
I
but you
should've-
want to talk to them now.
Yes.
Okay, so what I'm going to do is we're going to put you into a breakout room and let you have an interview with them. Okay.
Okay. Okay. Thank
And
you.
then come back out and we'll finish.
Okay.
Please.
And we have Miss Link back. All right, Miss Link.
There you go.
All right. State your name again, please.
Latanya Link.
All right, you've had an opportunity to speak with the public defender?
Yes.
All right. As to the arraignment portion of this from the PD.
Yes, Your Honor. Thank you, Nicole Van Blarkum, with Washtenaw County Defender's Office on behalf of Miss Link.
All right, you're waiving formal reading and standing mute to the charges.
Yes, Your Honor, and we reserve the bond argument.
All right, defendant having waived formal reading, standing mute, court will enter a not guilty plea. In this matter, I'll set probable cause conference in this case for April 9th, 2026, 9 a.m. From the people, Esteban.
Your Honor, we are asking for a 25,000 PR bond. This occurrence is between a mother and the victim is the daughter. We are asking no contact with the victim. We still need to determine if the victim lives with her father. So we would ask that there is a no-go to wherever the victim currently resides. And then we'd like to ask for all standard bond conditions as well.
Response.
We have no argument to that, Your Honor. We would also ask for a personal recognizance bond. My client has no prior assaultive history, and she has stated that the daughter can go live with the father.
All right, so is the daughter currently at the manor address?
Yes.
Or do we? She's
Yes.
currently at that 725 manor?
Yes.
Okay.
And Your Honor, Ms. Link has stated to me that her daughter's father can come pick her up if she is to be released.
Okay, well, there's a problem because if I order a no-go to there, and certainly I'll order the no contact in the the interim time with Phelan Lowe. But my concern is if I order the no contact or no go to the manor address, father comes and picks her up, defendant is still bound by my order because nobody's going to know.
Right.
Ms. Link,
Yes.
do you have some place that you can stay if I order you not to go to that address?
Well, that's my house. I have nowhere else to go. Because their dad was picking them up to get their hair done. He was coming to
I'm
pick
sorry?
them up. Their dad was coming to pick her up to go get her hair done. So she was gonna stay with him anyway the weekend.
Counsel, any suggestions?
Your Honor, would it be possible to get the address for defendant's daughter's father so that we could do a no-go to that address? So that she could return home to be able to stay there?
Yeah, I don't have a problem with that. I'm trying
I
to,
need the address.
I think what is going to occur is she's going to go stay with the daughter. What I'm concerned about though is if I order the 725, presuming the daughter cooperates and she goes to her dad's home, then there wouldn't be a problem ordering no go to that address. If everybody's following me. The problem is that if I put the 725, defendant can't go there until everybody can get all of that straightened out.
Understood, Your Honor. Give me just one moment, please.
Is this a felony? All right, here's what I'll do, because it's going to come to me anyway. So, this is Friday. All right, I'm going to set her bond at a $25,000 personal recognizance bond. I standard conditions, including no assault behavior, no possession of any weapons, ammunition, or anything fashioned to be a weapon. Ma'am, there should be no possession or consumption of any alcohol, recreational marijuana, or illegal drugs. I will order no contact with Kaylin Lowe. At this moment, I'm going to order you not to go to the 725 manor address. All right, you understand that, ma'am?
Okay.
Okay, ma'am, do you understand what I'm ordering?
Yes.
You're not to go there without a civil standby. What I'm going to indicate, counsel, is, if you can accomplish it today, that's fine, or you can try to reach me via email. If the parties can agree once the daughter has gone with the dad, I will sign an order allowing her to go back to that address and not go to the other address. Okay, so you just have to, if you get that to Ms. Weidling, then she'll make sure I can get it, and then I can get it back to the parties once we have all that established.
Okay.
Okay. So you understand what I'm doing, Miss
Yes.
Link?
Yes.
Okay, so don't go there until you have verification that there's an order that allows you to go there. All
Okay.
right. You just got to go hang out someplace. You just got to hang out until we get that order. Okay.
Okay.
All right. Is there anything else, counsel?
Your Honor, may I go into a breakout room with Miss Link one more time so I could get that address from her?
Did Miss Anderson tell you I don't do breakout rooms? And now you're going to get two?
She did not, Your Honor.
Okay, fine. We'll put you into a breakout room.
Thank you, Your Honor.
Thank you, Honor.
Thank you.
Thank you, Honor.
Court does call the case of the people versus James Richmond. Need to unmute him.
Kristen Lewis Perez here for the people, Your Honor.
Thank you.
He's unmuted.
He's unmuted. Sir, what is your name?
James Richmond.
All right, Mr. Richmond. I have two. These are warrants, correct?
Jim has a new felony,
Yes, I see that.
and the other two, one is a bench warrant for a pretrial, one is a bench warrant for a show cause.
Okay, gotcha. All right. Mr. Richmond, you've got 3 matters here before the court. You have a new felony case. That felony case is alleging that on or about March 21st, 2026, at the location of 3239 East Michigan Avenue, that count 1 alleges that you did commit the offense of assault with intent to murder. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony punishable by up to life or any number of years in prison. You understand that, sir?
Yes, sir.
Count 2 is the charge of assault to do great bodily harm less than murder by strangulation. You understand that charge, sir?
Yes, sir.
That's a felony punishable by up to 10 years, $5,000 fine plus court costs. Do you understand that?
Yes, sir.
Count 3 is the assault with a dangerous weapon, or commonly known as felonious assault. Do you understand that charge?
Yes, sir.
That's a felony punishable by up to 4 years incarceration, a $2,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
Count 4 is the charge of aggravated domestic violence, second or subsequent offense. Do you understand that charge, sir?
Yes, sir.
And that is a felony punishable by up to 5 years and or $5,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson, with and on behalf of Mr. Richmond, in all files, Your Honor, in the 2 new cases, we would waive any further reading. Reserve the bond document.
All right. Defendant heavyweight former reading standing mute. Court will enter a not guilty plea. I will set probable cause on this matter for, this is the 9th or the 2nd. Say again. April 9th, 2026, 9 a.m. As to bond from the people.
Your Honor, we are asking for $750,000 on this matter. We wanted to ask if you took the testimony on this case and referred to the bond rec form. It sounds like you have all the cases in front of you. So we just want to note that there was a large gap in time with no activity following his plea of torture. Felony assault and unlawful imprisonment is due to prison sentence of approximately 12 years, and that was from December 2007 to 2022, which was a parole discharge. He went back to reoffending very quickly with a DV case in 2025, and the violent circumstances of this offense just from last week. Incarceration has not been a deterrent, and his current probation has not affected the behavior. Right now, the people see this as highly lethal and a huge community safety concern, Your Honor.
Response.
Thank you, Your Honor. There's nothing else holding Mr. Van Blarken in custody Mr. Richmond in custody at this time. He did give us good contact information. In reviewing the charging documents, we see the severity of the crimes. He's not trying to diminish that at all. He's just looking forward to meeting with counsel and proceeding on his day in court. He would ask the court for a personal bond. If the court is not so inclined, then he would just ask for a reasonable bond to ensure his appearance at the next court date, and he would ask for the next available PCC date.
Defendant's bond in this case will be set in the amount of $500,000 cash surety. Although the standard conditions, including no assaultive behavior or possession of any weapons, firearms, ammunition, or anything designed to be a weapon. There's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. I will also indicate that the defendant is to have no contact whatsoever with Lori Ray Williams. That is, do I have my DV form, please? And you understand that, sir?
Yes.
And what I mean by no contact is, I mean that you are not to attempt to have contact with her directly or indirectly, either or through yourself or with other person's participation. You are not to contact her by electronic communication. That is included And that is you're not to, including but not limited to by phone, email, texting, internet, social media, and you are not to mention her at all online. I will also indicate that you are not to go to the address of 3239 East Michigan Avenue in Ypsilanti Township. I will order that if the defendant does post bond and if he is released, that he is to be placed on a GPS location tracking tether with the exclusion zone. Do you understand all of those terms, sir?
Yes, sir.
All right. Is there anything further from either side?
No,
Not at
Your
this
Honor.
time, Your
Thank you. Thank you on that case. I will also indicate, Mr. Williams, that you are also before the court on a charge on a failure to appear. This being case 2520702 on a failure to appear at a, is this a show cause?
It's a pretrial.
At a pretrial. I will cancel the warrant in that case. I will set your bond on that case at a $5,000 10% bond. I'll reset the pretrial for
April 15th at 8:30.
April 15th, 2026, 8:30 before Judge Barr. Then on the case 25F20428. This is for a show cause. All right. In this case, you failed to appear for a show cause hearing regarding the payment of fines and costs. I will cancel that warrant at this time. I will set your bond at an amount of $7,500. I'll give a 10% privilege on that. I will reset the show cause in this case too.
April 9th at 9 a.m.
April 9th, 2026, 9 a.m.
Yes.
9 a.m. before Judge Barr. Right? Thank you. Court does call the case. Is this my, oh, that's my cheap room. Lori Anderson versus Armani Lyman.
Good afternoon, Your Honor. Christopher Wilby, Wednesday, Vermont.
Your name?
Armani Langford.
All right. Okay, folks, where are we on this case? What is plaintiff's claim at this time?
I just wanted to let you know that I didn't get the whole 2,500 in, but
See that?
1,000. I will have the rest of that next Friday to turn in. I also would like to countersue just because I mean we're here. I'm still not peacefully.
Well, you needed to file something with the court before now. What is your claim in this case?
Your Honor. Claim $11,707. I'm sorry, that's. And that's inclusive of court costs.
How much is that?
And Your Honor, if you can't sense, this is a case that maybe the parties could be working together and there's some issues on the side. The defendant's statements that they wish to file additional claims. We would be requesting a judgment by no tribal issue today. However, I would not be opposed to an adjournment, considering I'm a covering attorney and Mr. Jarbo may be more familiar specifically with what's going on with the parties. I don't want to.
Right. Well, I am inclined, the total amount that's owed is, I'm sorry, what was that total amount again?
$1,707.37.
I had, how much were your court costs, counsel? See if because what I have is at the last hearing, March 13th, it was $11,529.39. And I don't know why that number would have gone up.
The amount that it's gone up would be the $178.
What is it? Okay, gotcha. All right. Anything else from either side?
I believe my client may be trying to make a statement if she wants to.
I have a inspection scheduled for April 6th with the Pittsville Township. And I need to have access to the property and make repairs for their certificate of
You're
completion.
gonna need to work, I understand that, but you're gonna need to work that out, comply with the local ordinance regarding notice. I'm not gonna get involved between the two of you trying to get into the property. You guys are gonna have to figure out a way to work that out.
I filed a 7-day notice. I will submit it to the court on Monday, but I can't.
7-day notice for what?
There's some things I need to clarify off the record, Your Honor, and we will go over those procedure things.
All right, so you deposited into escrow $7,600. When are you gonna have that other balance? Because you were supposed to deposit 2,500 in, and then I might consider something else, but you didn't do that.
Yes, I had came up short. I will have the rest of that next Friday.
Court's gonna find no tribal issue. I'm gonna grant a judgment for possession in the amount of inclusive court costs of $11,707.37. With a writ to issue, you've got to have all of that, the difference paid by March 6th. And I'm sorry, April 6th. That's a 10-day period, 2026.
How much again? I'm sorry.
Well, you can give me 11,707.37 minus 7,600.
$4,137.37.
Got to have that paid by the 6th.
I thought it was.
I'm sorry. I'm sorry.
I thought it would have just been the $2,761.60.
No, I'm going to give them, you were supposed to bring 2,500 in. I was very careful with you to get that in. That didn't even include the full amount to bring that up. I'm not going to hear a dispute where you were supposed to pay something. You haven't paid it to the court. I'm granting them a judgment. I really don't have a tribal issue in terms of this judgment. I'm going to grant them a judgment. That balance, I'm going to release the escrow to the plaintiff. And the balance has to be paid by the 6th. In terms of any inspection or whatever, or however you guys want to do it, you guys figure. Thank you.
Duration, Williams in custody? Yes. I'm sorry, I didn't know.
Yeah.
Oh, we were. What are we gonna do on her? Well, you know, we got a report report. Did you see that, sir? If she was declared competent. You need a copy of it for your file? As long as she's. I think, yeah. Well, I mean, if somebody ever pulled your file to look at it.
Probably emailed it to you.
Yeah, I think she did, but you need to put that in there because there was an issue on it. And somebody looked at it and said, uh-oh, that wasn't addressed. And then.
She would enter place then on the computer page. That would be too late because we had a hearing on this on January 30th and we proved up all the all the accusations, and then he raised the issue about some type of mental health, and you recessed it for the purpose of competence.
So we'll pick up the comp there.
Which my memory has it that the state had presented all the evidence and we had rested and we were on the
Duration, wheelbacks, please. No, I'm not pronouncing it. Duration. Yeah. Langston, y'all are ready to go when y'all are, okay, we'll take it up next here in a second. Okay, thanks. Yeah. Come on up. How do you pronounce your first name? Duracia or Duracia? Duracia Williams. And Mr. Kindler is here and the state's attorneys are here. As you know, there's a motion to revoke unadjudicated probation in this cause number 25 CR 425. Does the defendant waive a formal reading of this motion filed on December 12th of 2025? Can we proceed in summary?
Yes, Your Honor.
First thing we're going to do, there was an issue raised by the defense on the defendant's competency as to whether she was or was not competent to proceed with her proceedings. Ordered Dr. Edgar Pond, licensed psychiatrist, to evaluate the defendant. He is prepared, and we've received a report dated March 20th, 2026, finding the defendant to be competent. I'm going to call this report Court's Exhibit 1 on this date. It's here to stay. And it will be made a part of the record in this proceeding without objection. Okay. What do you think? Do we? No. So I don't think. Okay, it is received. And we can proceed in summary.
Yes, sir.
Raise your right hand, ma'am. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion to revoke unadjudicated probation filed in December of last year in this cause number 25 CR 425 states that on July 9th of last year, 2025, you were placed on 10 years deferred or unadjudicated probation for evading arrest or detention with a motor vehicle, a third-degree felony. Is that true? Yes. One states you committed the offense of assault of a public servant on or about October 19th, 2025 in Jefferson County, Texas, in violation of your probation order. Is that true or untrue? Did you? Have y'all talked?
I think she's previously heard.
No, this is the only motion here, and there's nothing on the face of this. I would write on it.
Judge, I wrote on mine that she entered her pleas of not true on January 30th.
Okay.
And
I wouldn't put that. Well, I thought, what are we doing? Is she admitting to anything here? And what's
she didn't admit to anything back on January 30th. We conducted a hearing.
Okay, what are we going to do today? Is she going to admit?
She's been found competent. I think the issue of competency was raised prior to a disposition.
Well, there it is.
She's been declared competent. So I mean, we proceed to a disposition at this stage.
Well, that's what we're trying to do. So what are we going to do?
Your Honor, my understanding is that the state presented all of its evidence on January 30th. I had Officer Lonnie testify about the proof as to the assault that he occurred to him, as well as the fleeing. And that was where the state limited its evidence on presentation on January 30th.
That was January 30th, right?
January 30th, counts 1 and 2. We have video evidence that showed that the fleeing was, in this lawyer's opinion, obvious. And then there was the body cam footage that showed where she struggled and kicked him in the appropriate areas alleged in the assault.
Yeah.
And if necessary, we can retrieve the video that was placed in evidence to remind Your Honor of the evidence. So after I passed the witness and Mr. Kimler was cross-examining the defendant, he was raising the issues about her mental stability. And out of caution, Your Honor, ordered the examination. She's been determined to be competent. I would ask that the court.
Let's pick up where we left off in that hearing.
I would ask that the court make findings of true as to counts 1 and 2 and proceed to punishment.
What do you have to say?
Disposition. I think that's accurate, Your Honor. And then if my refreshing my recollection of what occurred, I think while the report, if I could slip over and argue somewhat, while the report does find it to be competent, there are some indications of mental health issues that may militate in favor of more lenient treatment with the disposition of the NTRP.
Okay, then the court will find that based upon the earlier hearing and this hearing and presentation of evidence concerning the defendant's competency, where the defendant is declared competent, that the defendant pleaded true to, she didn't plead true, that the court found, based upon the evidence presented, true to allegations 1 and 2 by a preponderance of the evidence or greater, that the defendant committed the offense of assault of a public servant on or about October 19th, 2025 in Jefferson County, Texas, in violation of condition 1 of her probation order, and that she committed the offense of fleeing a police officer on or about October 19th, 2025 in Jefferson County, Texas, in violation of condition 1 of her deferred unadjudicated order. The court not only deems it meets the threshold for preponderance of the evidence, but the court found it true beyond a reasonable doubt in each of these cases. So what shall we do? Defense?
Well, Your Honor, many times, thank you. I think when people are faced, which some people are faced with an interaction with law enforcement, they react in a way that doesn't seems to defy explanation. I would observe that Ms. Williams is on probation for a previous offense of evading, which of course involves the interaction with law enforcement. Now, that's interacting with law enforcement in a way that has resulted in this NTRP being filed. I don't know that the
how much time
the competency exam goes into her mental health history rather extensively. She's in a position to kind of maybe indicate to the court why she seems to be triggered by interaction from law enforcement. I would observe too during the incident now that's given rise to the allegations of the NTRP, there was no contraband found in it, or there really seemed to be no rational explanation for her actions, other than just she has, I don't know, I'm not an expert, but PTSD and a triggering event dealing with law enforcement. I'm not trying to excuse it, just maybe trying to contextualize it, that she could maybe tell the court what was going on in your mind if you had this interaction with the officer.
No, I blacked out.
She's mumbling. I can't hear you.
I blacked out. I really don't even remember. I'm scared of the police. I'm scared of the police.
Is that the root of your troubles, you think?
I believe it is.
Nobody knows more about you than you. Let me ask you, have you ever been convicted of any other criminal offenses?
Yes.
Yes.
Okay. How many times?
I don't know.
You don't know how many times you've been convicted of a crime?
Twice.
Okay. Is that your
Violation, yeah. Twice.
Is it?
The DWI,
No, I'm talking about for any misdemeanors or felonies that are above a Class C misdemeanor, above a traffic offense. Crimes.
Probably 5 times.
Sir, ma'am? 5? 6. 6 times.
It's closer.
Well, we're not playing horseshoes. This is real life. You should know better. You should know more about you than, well, I shouldn't have to correct you on that. This should
But that's 2, 4, 6, 8, actually 9 times. 9 times. 9 convictions. But what does that say? You know, that's from 2011 through 2024, and now this one. You're looking at on a probation. I mean, I stuck my neck out on this one with this criminal history, and it's assault, prohibited weapon, switchblade, and brass knuckle or something. Assault, family violence, resisting arrest, failure to identify, driving while intoxicated, resisting arrest and search. Those are all they're misdemeanors, but they're still, you were arrested and then you had to serve jail time. You every one of those were, one was 2 days, one was 9 days, and the rest were 60 days or more. Anyway, that and evading arrest has consequences because this is, let's see. You have 3 resisting arrest convictions before this one. So, evading or resisting are in the same family. They have consequences. All right. He has 83 days credit here. This is a 3rd-degree felony. So what should we do?
Judge, my suggestion is a 5-year sentence. I think it's warranted by the criminal conduct prior to her being placed on probation. It's additionally warranted because of the offense, it was the felony offense that was committed that Your Honor saw the video on. And frankly, I still remember this officer testifying now 2 months ago. He showed great amount of discretion with this individual. He could have charged her with the same offense. She was on probation and chose the misdemeanor offense of fleeing instead. I believe Your Honor even commented on the record about that, just the length of time that went with here and then the number of officers that it took to get her just to comply speaks volumes.
Right.
Then if we go past that, and this year she's had 10 different violations that she's been written up for in the jail that she just doesn't want to follow rules. I don't believe putting her back on probation is going to be beneficial for anybody. Certainly not for Jefferson County. I think the 5 years would be appropriate.
Defense.
Your Honor, I don't disagree with Mr. Ham's characterization of the officer's conduct in this case. I think he showed remarkable discretion both in interacting with the defendant and his choice of charges to file. So certainly I don't take any issue with the officer in this case. He went above and beyond to try to treat Ms. Williams appropriately.
What are you suggesting we do?
Well, without hearing from the probation officer, I don't know if they're willing to continue to supervise her. If there's still a chance that maybe with some sort of mental health intervention, we may be able to remediate the issues that she seems to have occurring with law enforcement. That would be one thing. If the court is inclined to revoke her, I would ask the court to consider taking into consideration mental health issues and consider lower end of the statutory range.
Anything from probation?
No, sir, we just didn't have a chance to really spend any time with her. I mean, she got on probation in July. She got her new charges in October.
Okay.
But during that time, she never told us anything about any mental health issues.
Yes,
So we'll address that.
Yes, sir. Anything you want to add, ma'am?
I mean, I asked my probation officer, but I was in Houston, so I don't know who I should have talked to. The one in Houston or the one, I mean, it was kind of confusing.
She may have been reporting in person.
Well, the important thing, the first thing you have to do is not commit another crime, which you did twice, along with the other 9 prior convictions. Court finds that these are new. What are y'all going to do with those?
She probably has sufficient time served on these.
Which ones, Judge?
the misdemeanor.
Yes, the October 19th.
All right, so I have a felony offense that's pending for the assault on peace officer. And in misdemeanor court, we have the fleeing offense.
Is that where it is?
Yes, sir.
Right, I will find that if nothing further, there is sufficient evidence supporting this motion to revoke unadjudicated probation and grant it by preponderance of the evidence or greater, as the court finds allegations 1 and 2 proven true, as the defendant is admitted these violations, and the court earlier in the hearing found them to be proven true not only by preponderance of the evidence, but beyond a reasonable doubt that assault on a public servant and fleeing a public officer criminal violations were committed by the defendant on her probation. Thus, that is a violation of her probation order. Her probation is hereby revoked. Earlier in this case, the defendant had pleaded guilty to the third-degree felony of evading arrest or detention with a motor vehicle voluntarily, knowingly, intelligently. There was sufficient evidence supporting her guilty pleas from State's Exhibit 1, guilty plea from State's Exhibit 1 admitted her plea hearing to support her guilty plea to find her guilty beyond a reasonable doubt. I had deferred any finding of guilt at this time. The court is moving forward based on her violations of probation. I now find you guilty beyond a reasonable doubt of that third-degree felony you had pleaded guilty to back in July of last year. And I find you guilty beyond a reasonable doubt. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You will be given credit for all the time you have served in accordance with this case. Please do that. Follow the rules. Anything else? That is all. Come on up, man.
He is on the tag.
Thank you. Risha, come on up. 25 CR 183A, this call. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
She does.
In summary, this indictment alleges that on or about October 19th, 2025 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer or a judge. Do you understand what you're charged with?
Yes.
This is a second-degree felony, which carries with it, if convicted, a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Do you understand?
Yes.
An agreement's been reached. You would be pleading guilty. Sentenced to 4 years in prison to run concurrently with other cases. Is that your understanding?
Yes.
If I follow this, you have no right of appeal. Do you understand? How do you plead to this? How do you plead to this, guilty or not guilty?
It doesn't matter.
Are you pleading guilty voluntarily and because you are guilty? Show you what's marked Exhibit 1 here. Did you sign that voluntarily? Understand it? Discuss it with your attorney. Is everything true and correct? State's Exhibit 1 tendered without objection admitted. The state you're mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. If you were guilty of the crime charged in any lesser included offenses and you are giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God. Correct?
Yes.
State's Exhibit 1 presented and it is admitted into evidence without objection. Pre-sentence report is away. I will follow this agreement. I'm going to find you pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this offense. I now find you guilty of the second-degree felony of assault on a peace officer. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. In this case, you will be given credit for all time you have served in accordance with this case. Do you understand what has happened today?
Yes.
That is all. Thank you.
See what you mean.
Yeah, the
1 and 2. And then they're gonna work out the sentences, basically.
Right. Well, that's what it sounds like.
Yeah. Was done. Did you realize that?
This is who is
It's not a indicted case, it's the one you.
Oh, this is the one you set the bond on.
The bond thing,
Oh.
is there's.
I know about this one.
Yeah.
yes, okay.
You just wanted to go over it today.
All right. There's a matter that was presented to the court yesterday by the Criminal District Attorney's Office for Jefferson County, Texas. And you are Charles Wilson III?
Yes, sir.
And you were here with Mr. Adams, your attorney and the state's attorney. The state of Texas filed a notice for a review of a bail decision. You had been placed on $65,000 bond for an aggravated assault and a $15,000 bond for family violence. And the state of Texas, the district attorney's office deems that amount is insufficient under the law to ensure that you will properly appear and answer before the court and to ensure the safety of the community and the safety of the victim. And for those reasons, they ask for a review of this bond decision. And the court has 24 hours to make a decision. And so the court made a decision yesterday because of some emergency matters that prevented all of us from getting together. But I had to make a decision. And this court did make a decision finding this finding this request in good cause, for good cause, and upon reviewing the public safety report, the probable cause affidavit, and the other documentation in this file on these cases, the court raised your bonds to $100,000 in each cases, and also ordered that if you post these bonds, you must remain at home. You would be on home confinement, except for allowing to leave home only for necessities of food, medical care, and meeting with your attorney. And you must travel to and from your house in the most direct route possible. You must have a GPS device if you post these bonds so that we know where you are at all time, and to ensure that you're not violating these conditions. And also, I think those are the essential features of what the court did. Now, because the rule of law states I have to make a decision, we couldn't get together. I asked you and your attorney in the state to have a hearing today to show cause why and present any evidence why the court's decision should not be continued and enforced based upon what the court deemed yesterday. And I'm giving the defense an opportunity to be heard and to present any additional evidence you want me to consider. And so I will consider modifying the bond decision if I find good cause from evidence presented. Go ahead.
Yes, Your Honor. Your Honor, specifically, Judge, under 17.028, it's the state burden to show that the safety of the community and ensures that the safety of the victim of alleged offense warrants this increase or request to review his bond. Your Honor, we ask that the state disclose you what we would believe to be Brady information as it relates to the state's burden as to safety of the community or the safety of the victims. It's my understanding, and I'll ask that the state to disclose if this is true, that the alleged complainant did not want the bond to be increased, one, and that two, in fact, this Tuesday, she went to the district attorney's office to have the charges dropped. If that is true, and that would be Brady, that would clearly be Brady for purposes of a bond hearing. If she in fact went to the DA's office to have the charges dropped, and if in fact she did not seek to have this bond increased, then on the legal issue of 17.028, safety of the victim, that's clearly Brady, and that would go to that particular, that's my position. My position would be that would be Brady, and I would ask the state to disclose whether in fact.
And how does your client know that she went and did that? I didn't tell anybody because I don't know about that. How did he know? Has he been in contact with the victim, which he's not supposed to be doing?
Well, let's say this. If in fact that is true.
Yeah.
Again, my position.
If y'all want to conduct a hearing on your own, that's fine, but
I think that that's Brady. That's sorry.
The court's decision. The court's decision. Even though the state of Texas always has the burden of proof in these matters because of the presumption of innocence standard, this court still has its own independent access to the probable cause affidavit and the criminal history, which I am required by law to review in determining bond issues. That's why I made my decision and found that the bond was too low and not appropriate under the circumstances this court reviewed. I'm giving the defense an opportunity to present any evidence you want.
And I have evidence
to that the court will consider in whether it will modify my bond order from yesterday. Go ahead.
Right. Well, Judge, Mr. Laird says that he's unaware of that, but if in fact that is true, our position is that that's Brady, and that would go to the safety of the community and the safety of the victim. And I got some more evidence.
Yeah, Brady.
That's Brady in our position.
The experience has been this office has been very sensitive about Brady. We all should be. We all are, and I've not found them to intentionally.
No, I'm not saying he's not
Brady material. They honor their oath and conduct it responsibly, just as you do in your.
Yes, sir.
Go ahead.
Judge, I would just ask that, I understand he can't do it now, but at some particular point in time, since he does not know, that he look into whether or not the lady came up with the drop charges, and he look into whether or not she did not pursue this. But I got evidence other than that, but that's why I got other evidence.
Okay, that's the court will note that, and it's in the record. But at the end of the day, the decision is in the executive branch of government, not her.
Right.
Somehow, some way, she was a complainant somewhere along the line. And when that happens, then the executive branch of government takes over and does what it does under their responsibilities of the oath that they have taken under the Constitution and the laws of the state of Texas and the United States. So I don't find that they've done anything inappropriate in this case, except follow their oath. And we've had situations where complainants change their mind for whatever reason. The worst thing that can happen, though, is if they decide to change their statements of victimization based upon influence or coercion or even contact on behalf of the defendant, it would be catastrophic for you. Because this court takes no prisoners when that is found to be done. You cannot disrupt what this Constitution stands for and what the laws stand for. And that's what happens sometimes when people behind the scenes try to influence others who are involved in the criminal process improperly. That if that is done, it will be dealt with severely. But nonetheless, I don't have any reason, I don't have any information before me to change what the court's decision was yet.
And
That's why I'm giving y'all a chance.
and I'm gonna call my client as a witness.
Charles Wilson III,
Yes.
raise your right hand. You solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right.
You have to speak out.
Yes, sir.
All right. Your hand. Thank you. Go
All right,
ahead.
Mr. Wilson, you understand that I'm not gonna ask you any questions at all about the facts for this particular offense. I'm not asking you nothing but if you understand that. Yes, sir. And you understand on our rules of evidence that you testifying on a preliminary matter does not subject to the cross-examination for any other issues. The only question that I'm asking you on about is for financial abilities, right?
Before you get through, I don't think that's accurate. I think I can cross-examine him on any issue because part of the rules or part of the reason the judge made his decision was on the safety of the community. So I can talk to him about the offense. So before you put him up there, you better get a ruling.
Judge, I don't think that he's subject to cross-examination. All I'm asking him questions is about his basic income and his ability to afford a $65,000 bond, and asking him about his income has nothing to do with whether or not he committed family violence against this lady. And
I think it does. The issues on bond for the ability to follow the bond conditions and whether his release would be a safety to the community or the victim or others. They can go into those because part of the bond conditions is not to commit first thing, don't commit another offense. But it opens you could possibly open the door for this subject matter to be allowed. Yes, Langston, what are we?
yeah, we're ready. Come on,
What are we doing?
I think we're gonna just.
I've looked back at Rule 104, and if as long as he sticks to financial, I cannot cross-examine him on the offense unless he talks about the offense or brings it.
So what are we going to do?
I'm just gonna ask a quick financial question, and we can let you make the decision, whatever it's gonna be. It'll be super fast.
And this is.
This is the state of Texas has requested a review of.
Yes, all right.
All right. Did you hear what I'm not gonna ask you anything about the facts of the case. Don't tell me nothing about the facts of the case, right? You got me? The only thing I'm asking you is a money question. That's it. Got to do with money. Don't say nothing about the case. You got me? Yes, sir. All right. So you understand that Judge DeRuin, who initially set this bond, I think he said a $65,000 bond and a $15,000 bond, right? Yes, sir. All right. So if you go to a bail bondsman and they charge you 10%, that'd be $6,500 and then $1,500. It would be a total of $8,000, right? Yes, sir. Okay. Right now, do you have $8,000 in any bank account anywhere? No, sir. Do you have $8,000 that you could borrow from anybody anywhere? No, sir. Do you have $8,000 worth of property that you could sell and make this bond? $8,000. Do you have that anywhere? No, sir. At the time that you went to jail, did you have a minimum wage job working at Church's Fried Chicken? Yes, sir. So basically, working at Church's Fried Chicken, minimum job, you would probably qualify for some kind of a federal financial aid or something, right? And then as far as a house, apartment, home, you don't own that, you live with your mama, right? Yes, sir. So as far as the bond being sufficient for you being able to appear in court, actually the judge could lower that bond from 65,000 to a lower number because specifically under the rules, when the state of Texas asks for a bond review, and the court pointed out in the prior hearing, the court could actually determine that the existing bond is excessive. So based upon what I read in the court reporter's notes, Judge Stevens can say that that $65,000 bond is excessive because of your financial situation. Is that right? Sure. So at the end of the day, I told you I wasn't going to ask you anything about the case, right? Sure. And I didn't ask you one thing about the case, right? Sure. But in terms of money, a $65,000 bond would be excessive for a man who doesn't have a job. He lives with his mama. He has no property that could be sold.
And I think, you know, and I ask to take judicial notice. I think his age is 23 years old. So a 23-year-old man, no job, no, when I say no job, you can't work at Church's Chicken if you're in jail right now, right?
Yes, sir.
So you done lost the Church's Chicken job, which is a minimum wage job, right?
Yes, sir.
And at Church's Chicken, you basically frying chicken and doing stuff like that. Is that right?
Yes, sir.
So are you asking the court to do what it can do, which is lower the $65,000 bond to, let's say, 10,000? He can lower it. You understand that? Right? All right, that's all I asked, and I told you I wasn't asking nothing about the case.
Anything from the state?
Not on the financial judge.
I find the, anything else? I find the bond, the setting that the court, made based upon his criminal history and the probable cause affidavit, the circumstances to be fair and appropriate under these circumstances. And I deny the request, and we will set this for.
I don't think it's been indicted though.
Yeah, once I guess there's an.
It's been received, it's coming up, but
okay, when the indictment comes, we'll try to get a setting as soon as possible, and then you can resubmit your request.
All right, thank you, Judge.
Thank you. All right, let's go to Calvin Walker. Thank you.
Court calls the matter of Brittany Lynn Wood Wright versus Carrie Bazan, file number 26208178PH. This is the petitioner, Ms. Woodwright's motion to seek a personal protection order. She's in the courtroom. She's in pro se. Ms. Bazan also appears in the courtroom. She's also in pro se. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Thank you. For purposes of history in this matter, Ms. Woodwright filed an ex parte motion seeking a personal protection order against the respondent. That was on March 16, 2026. The court reviewed that petition the very same day and issued an order the very same day denying the petition for personal protection order, stating that the petition is not clear relative to two alleged unconsented contacts. When it appears some of the allegations involve the petitioner's minor children, petitioner may request a hearing if she wishes to, with notice to the respondent. It is the petitioner's burden to seek a personal protection order by a preponderance of the evidence. And so the burden rests with you, Miss. What is the reason you're requesting a personal protection order?
Your Honor, it has been an ongoing situation that the respondent has been using slurs against my disability. She has been screaming and cursing for children playing in a commons area upstairs in our own level apartment. She has come out and produced a cell phone and recorded myself and my children while she has blocked off the entrance and the stairwell that is the only entrance and exit in the building, while she proceeded to insult me and use discriminating comments. And then she then proceeded to return to her home when I made a police report that same day. It is in the massive stack of evidence. She continues to post on her social media in regards to myself, my mental health, my disability, my whereabouts, my ins, my outs. When I'm doing something, even carrying my child up the stairs, saying I'm not disabled enough to be doing that. It is insulting to myself. It is insulting to my children to be mentioned on her personal public Facebook page. And she has even gone as far as unfortunately going to the police department and telling them words that did not get said and using an image that she had requested over a year ago or 6 months ago in lieu of it being where I was at the bus stop waiting for my children, and I had seen the Seaboing chief's wife. She had then made derogatory remarks against me towards the chief's wife, which then caused a stir with me and the chief of police. It caused an emotional distress, causing.
So she allegedly made statements about the chief's wife that made a problem with you?
She said it was me. She said I said something in the matters of his wife reporting for booty duty at somebody's house. And that was not said. And it was a vague picture to show where the house was, because she said, which house is it? And I sent a vague picture. And this was over 6 months ago. And the chief then responded in upset, and that is understandable, but it caused me grave emotional distress, which caused anxiety, hyperventilation, to the point of being extremely ill, to the point of almost blacking out and needing emergency service from my caretaker. And I was on bed rest for the rest of the day.
So, I mean, I reviewed the initial items you had submitted to the court for the determination whether to issue an ex parte personal protection order. And then in this motion, I mean, there are just pages and pages and then comments. I mean, that
I apologize for the comments.
well, it's impossible for the court to understand what this is about. Now, mind you, I don't know if this is hearsay or not. I have no idea, but I need to have firsthand observations by you to indicate 2 or more unconsented alleged stalking type of situations, which would warrant a personal protection order. But your original request was from, you even mentioned over 6 months ago, correct?
No, Your Honor. This is really confusing, and I had hoped that we had gone last, because it's a lot, and I know you like short and sweet, but
That's not true.
There's no short
Excuse
to
me,
this.
Miss, short and sweet. Oh, no. If you wanted to see short and sweet, you should have seen my predecessor, whom I highly respect. My predecessor, the Honorable M. Richard Knobloch, it would be more than quick. I allow, and I'm not saying he never did, but I allow the parties the opportunity to speak. And I even asked them again, is there anything else? I do that for a reason, because you are entitled to have a hearing and to bring all this information out. But I take umbrage with that statement that the court looked short and sweet. That's not how we work.
Well, I meant that in no disrespect.
And I'm not taking it that way, but I want to make sure you understand that's where we stand here. But I do recall, though, in your request originally, you referenced June 2025.
Yes, that is when this whole matter had started, the end of our friendship, Your Honor.
Oh, there's a friendship.
There was a prior friendship.
Okay, that's fine.
That is all. I wanted to get the whole truth and nothing but what happened. I have a timeline, and it is an outstanding 10 pages long. And it is just a lot of her posting on social media in correlation to what she has never brought to me personally without screaming and cursing at my children first.
Are you alleging it's slanderous?
I am.
There are other causes of action which I can't get into, but how does that apply toward a personal protection order regarding stalking?
Your Honor, she has mentioned, and it is my apologies. I'm just going right here and read it from her own post. Again, I apologize for the delay and everything else. I am quoting her own personal Facebook page. She makes a comment that she simply said, someone who claims to have PTSD sure causes a lot of stress and everyone in the building, if she would stay out of the hallway and stop yelling at everyone or allowing her children to play board games in the hallway, there would be less noise and there would be no complaints. As it is listed in our lease that a commons area is not a playground. If she claims to have such a disability, she can sure climb stairs, stand in the hallway, making up her own stories and speaking Spanish off of the top of her railing to us. I watched her carry groceries up the stairs. I watched her carry a baby up the stairs. She claims that she's been in bed. She claims that her doctor told her my stress is causing her complications. There is no need for someone to be watching the ins and outs of anybody who is coming into the building, especially when making derogatory statements about someone's disability, to tell me or tell her whole Facebook that she is watching me go up my stairs, go down my stairs, carrying my child.
And I'm not trying to be cute or coy with this, but does it ever mention your name?
She posts my personal Facebook page that has my name on her Facebook.
No, I asked whether or not these posts list your name on it.
No, but I am the upstairs neighbor that she insinuates, sir. Because she says in her Facebook as well, that every other neighbor in our building is cool and it's just her. And she only yells at my children and only causes issues and disturbance between me, even if everybody else is out of their apartment with us.
So I clearly noticed Chief Repke is here, Chief of Police, Sebring Police Department. I'm assuming you've called him regarding these allegations, correct?
He first came towards me with.
No, I asked a question. Have you called him regarding these allegations?
I have not called him.
Why not?
I have called Sebring Police, but not him personally.
Oh, I'm sorry. Well, my question was too specific then. Did you call law enforcement complaining of these allegations?
I certainly did, sir. And
Okay.
then they.
And was the Sebring Police Department sent out?
The Sebring Police Department had made a call towards me and said, just make a note of it if you have a notebook.
Did you reach out? Because it appears that, and I'm looking at one of your pages here, this was a complaint form to the apartment complex, and it references the Sheriff's Department. The tenant of A9 was served PPO paperwork by the Huron County Sheriff's Department. So has the Sheriff's Department been involved as well?
Yes, Deputy Loss had served her the hearing paperwork.
I see. So this is as of March 23rd, correct?
Correct.
Okay. Anything else you want to bring up?
I believe it is discriminating against my disability that she uses her personal Facebook to make an appearance of myself that is not valid. It is falsified information. She has used the police against me in saying that I make false reports, which I have only made reports against her. The fact that she is talking about my children literally every day. And she claims that she is making monetization, more money on the drama here. And this is my personal life. This is my disability. She has no right to say, I am not disabled enough for her own, and then post it on Facebook, having people weaponize themselves and claim to say they can come to my town of Sebring and open a can of whoop ass against me. I have done nothing against this person except for tell her to shut her mouth, stop screaming, stop cursing, come up and talk to the parents. There was no Spanish. I don't speak Spanish. She is making false claims against me. She even has people of Sebring that have businesses comment about my mental health and how I am a psycho bitch. And that is unacceptable.
Do you have any other witnesses you intend to call?
Not present, but I do have an exhibit
And what is your proposed exhibit?
It is her final message to the world about how she can continue to post whatever she wants on Facebook because it's her Facebook. And it doesn't matter who she posts about because she's allowed to do what she wants, even if it is harassment, even if it is saying she can stalk me and know my ins and outs, and that she deserves a peaceful environment. Yet, so do I. I deserve to have a space knowing that I lived there for 4 years. She still moved in. She claims that I have been intimidating her, and then she claims against that, saying that she's been ignoring me. I honestly forgot she lived there until these issues arise, sir.
Okay, hold on to that.
Mhm.
I'd like to hear from the respondent. Miss, how do you respond to all?
I'm here today because Brittany is my neighbor and we used to have a friendship. Our friendship ended in June of last year. I have made no physical contact with her besides a brief verbal altercation in the hallway about her kids being loud. I've lived in this apartment complex for over 6 months. I've never interacted with her. I went on with my life since June of last year. I've gotten pictures put on my door of me coming into my apartment with her own contents. I made police reports. I
Who did you make
also,
police reports with?
the village police
Village of
department,
Seawood? Okay.
yes. And I've only made one police report in the last 6 months since our friendship has ended. There's only one police report, and that's since I've lived, and that's when it started in March. I believe it might have been end of February, beginning of March. We stopped being friends because Brittany was complaining about other neighbors. I have a lot of personal messages between me and her about those neighbors. And I also have messages of pictures of those neighbors that she took in public places. I also have messages about saying she's going to kick the neighbor's teeth in. I also have messages from Brittany, how she's upset because she didn't like the way that the village police was handling her complaints, which I also have a copy of. 9 additional incidents for the Seawood Police Department have responded to complaints from Mrs. Wrightwood, which didn't result in a report being filed. They were documented in their daily logs. There's only one police report made against me. If I've been harassing her, as she states in her petition, for over a year, also with threats of saying that my boyfriend flashed a firearm concerns, that I have a pattern of habitual harassment. I called the police because I didn't know what to do about it. We had a brief verbal altercation in the hallway about her kids being loud. And since then, she has fixated and pivoted her harassment towards me because I showed the chief of police all of her personal messages. Even the ones regarding to he's not doing his police duty, he must not be doing his booty duty. And sent me a picture of their personal vehicle at someone's house in the community. I didn't know whose house it was. I sent all that information over to the chief of police himself so he could review it. In his defense, he confronted her and questioned her about it. That's his right to do. Why did you take these pictures? He questioned her. I think there might have been a post that he made on his personal page about it because it's really concerning behavior. No names, who took the picture, who sent him the picture. And since then, Brittany has filed so many complaints to the housing department, and these didn't start until 3/15, which was the day of the incident. She's been retaliating harassment against me because I'm sure she's probably embarrassed about her behavior. Integrity means a lot to me. I've been in this community for 5 years. I lived down the street from Brittany. Even after we weren't friends, we went our separate ways. I didn't want to be friends with her anymore. She didn't want to be friends with me because the chief of police I have those messages, was on my personal Facebook page, and she unfriended me. And I quote, "This is the last time I've ever contacted her on social media, and this is June 9th, 2025. If you didn't want me to talk to him anymore, that's kind of an odd request. It's not okay for what he did," meaning I'm acknowledging her feelings because I'm an empathic, I have empathy for other people. "Life goes on, and I won't sit and be mad every day about it. Push me out, that's fine. I don't trust people anymore either. Instead of coming to tell me you're upset, you unfriend me. That's not fair. That's your choice. Sorry I bothered you. You were my only friend here." She said, "Exactly. Life goes on." I said, "Please leave me alone. I didn't do anything wrong." And she puts, "Laugh out loud. You're something else." She then texted my boyfriend and said, "Grow the F up. You gotta throw your 2 cents in another platform." I responded, which I shouldn't have. This was June of last year, by the way, Your Honor. I said, "Now you're texting Alex's phone. Don't harass me and get obsessed over a situation that you created in your head. I didn't do anything wrong but tag a cop in a funny post, and you've all been out of shape." It was a funny TikTok trend that I tagged Chief's personal Facebook in, and she was offended by it. She made me her enemy.
Okay, I just want to interrupt here for a second. The petitioner is alleging that you're posting all this on Facebook about disability and all this stuff. How do you respond to that?
No, I have personal messages between me and Brittany that was included into housing complaints that she was filing disability discrimination, and that was my defense.
So you're denying posting anything on Facebook?
Sir, it is 4 inches thick. I went through some of it, and it's very emotional, distressing to see her own responses to things that are not even regards to her. I have a lot of neighbors. Some of my posts, they might have been about her, but it's nothing threatening. I have had Facebook for 16 years, the same account. I blocked her. I've changed my name, my profile picture, my cover photo, my location, and she's documented all of that. I don't know how she's seen my page. I tried to block her from it, but then she puts it on my door. Even after she filed the PPO, she continued to put stuff on my door as new evidence. She's taken pictures of me exiting and leaving my apartment complex and put it on my door, insinuating I called her a psychopath and a pussy. Excuse my language, I don't even like talking like that. But ever since I alerted the chief of police about her behavior, her harassment escalated.
Okay.
And I've lived here for 6 months.
I think I've heard enough.
I'm sorry.
No disrespect. Court sua sponte calls Chief Repke. Chief, would you please step up to the witness stand? Always welcome. Please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do. Sir, please be seated. Thank you. Please state your name for the record.
Stephen Repke, last name spelled R-E-P as in Paul, K-I-E.
Your employment, sir?
I am the chief of police in the village of Seaboyne.
How many years so employed?
As the chief here for
How many years in law enforcement?
40.
In your duty as chief of police of Seaboyne, are you, as a part of your overall duties, to address complaints that may be filed by residents or anyone within the village of Seaboyne?
That is correct, sir.
And have you had the opportunity to hear what has been stated so far in the courtroom regarding what appears to be a dispute between neighbors within an apartment complex?
I have.
Okay, how many times have you gone out to either residence since June of 2025 pertaining to issues between neighbors?
Necessarily not gone out to, responded to telephone calls in context with the police department. I would say countless,
Countless?
countless. I would 15 to 20 of calls I've taken in regards to complaints about the rules being violated in that apartment complex.
Right. When you had received these calls,
And it's not just me, Your Honor, it's my officers too,
sure. So at least 15 to 20.
that I could just off the top of my head.
Okay. But you're stating there could be more.
Yes, sir, that the other officers may have taken a phone call and didn't find that it's grown tiresome.
All right. And is it fair to say that when law enforcement receives a telephone call, whether it be through, well, typically through dispatch, you have a duty to follow through with it, right?
Correct.
And are there occasions where phone calls may come in that may not go through dispatch, for instance,
Correct.
that you would or your department may address on the phone, and that would be the end of it?
As advice only, yes, sir.
Sure. And is that part of what has been happening here?
Yes, sir.
What are the complaints regarding?
Overall, noise in the hallway, noise from other apartments, kids riding their bikes in the parking lot, getting too close to vehicles, parking complaints about people parking in their parking spots, things like that.
And does this particular apartment complex have a manager?
Currently, I'm not sure. Then they did have a part-time manager.
All right. And typically, are those matters addressed through the apartment complex?
That has been our advice, that it would have to be addressed through the apartment complex.
So anything that you've received complaint-wise from June 2025 to present, that would be alleged criminal activity by either of these parties?
None.
So being the eyes and ears of the village of Seaboy, bottom line, what's going on here?
It occurred before June too. There was other neighbors that would make complaints.
Against who?
Miss Woodwright.
Okay.
There's others that have moved. It's been kind of a constant thing. And then it seems to have ramped up since June. And then it really ramped up once Miss Bazan made me aware that pictures were being taken of my wife's personal vehicle and forwarded to other people in town.
Is that concerning?
That was very concerning, Your Honor, so concerning that I made my officers aware of the incident, and I also made friends and family aware of the incident. My son reacted. It was my son's house that the pictures were actually taken at, where we often take care of our 2-year-old grandbaby that has a very rare disease. One that they really can't even put their fingers on, and my wife's often over there. So it touched a nerve, especially when my wife, who is a labor and delivery nurse and has dedicated her life to helping others, is accused of being on a booty call. I was highly offended.
Now, regardless of, and yet I'm not trying to put that.
No, sir, I understand.
Down, but does that have anything to do with how the department investigates any phone calls coming into your office regarding disputes between neighbors?
Absolutely not. It seems to have ramped up since then to the point that we actually received a complaint via Child Protective Services, making allegations against Miss Bazan and her boyfriend that about a handgun being waved and things like that, which was never reported to the police department, but it was felt that it should be reported to CPS. I just feel that this has become a retaliatory thing against Miss Bazan.
Ms. Woodwright, do you have any questions of the chief?
I just know, Your Honor,
Oh, no,
that
just questions. Do you have any questions?
Miss Bazan had contacted Chief after she had threatened me and I had made a report. And I know.
Wait, is
for a
that
fact-
your question?
Yes, I would like to
Okay,
know,
please phrase it in the form of a question.
did Miss Bazan make a report and then or after I made a report, contact you in regards to something that was about 6 months ago. And then that's what caused the concern and stir up between you and I.
Ms. Bazan did, I had an officer follow up on a report that Ms. Woodwright had made. Ms. Bazan had come in on a weekend when I wasn't working. And the officer was able to follow up on the allegations. And then Ms. Bazan did contact me after that. I am very transparent in my community. If people want to friend me on Facebook, I very seldom turn it down. I've actually known Ms. Bazan and her fiance since they were teenagers from my time in Cairo, Your Honor.
Next question.
Would that include a personal relationship that would insinuate more of a belief system that the accuracy of what was told and shown to you against me, sir?
Would you please say that again?
The imaging and communication that allegedly happened between myself and Ms. Bazan, would your personal relationship between you and Mrs. Bazan have a greater concern for more of a belief that this is accurate and true communication that she and I had?
Not necessarily. I was concerned about the fact that my family was brought into the matter and that pictures were being taken of my family members within the community. I felt that it was a potentially dangerous and troubling situation. So did I weigh a relationship any deeper or heavier with the Bazans and the Davises? I would say no. I try to weigh out everything as equal as possible and approach everything as impartially as I can. However, was I very concerned? Absolutely. Your actions by taking the pictures of my family within the community, I found extremely troubling. I take it as a threat to my family.
Any other questions?
And was there clarification made between yourself and myself of what had happened over social media after?
I accepted your apology. But that doesn't mean that I still do not find your actions extremely troubling. And it has caused apprehension within my family. My wife, my son, my children, my daughter-in-law, because I have to put them on notice that they're being watched in the community.
Any other questions?
If this was such a troubling situation and taken so seriously by Mrs. Bazan, why didn't she communicate that towards you sooner than until after a police report was made against her for harassment?
That's speculation. That's going into the mind of another party, which this witness does not have the ability to do. That motion, I'm starting that question. Do you have another question? I have to follow the rules of evidence.
Nope, I just know, Your Honor, that this happened over 6 months ago. And if there was no date of when this occurrence
You
had
can
happened,
bring your argument. Do you have any questions, though? Any further questions?
was there a timestamp of when this had occurred?
I did not see one.
So it was a valid threat of right now presence.
I deemed it as such.
No further questions.
Do you have any questions?
Me?
Yes, of the chief.
I would just like to know why there was false allegations made of flashing of a firearm.
That's beyond the scope of this witness as well.
Other than
That's
that,
assumed as facts, not in evidence.
Other than that, I don't have any questions.
Chief, you may step. Thank you, sir. You're welcome. Final argument.
My argument, sir. She is being dishonest with you. She is portraying the victim of something that has been an ongoing situation, which there are TikTok messages after I just unfriended her, Your Honor. And she then went to my partner at the time, messaged him, went to my TikTok, messaged me, blocked me, unblocked me, messaged me. I texted her phone that she gave me her number to, told her to just stop. Words lesser than what was said, stop. She then unblocked me and had more to say, which is in the documentation.
Miss, your final argument.
My final argument is I have not committed any crimes. I do admit to having a verbal altercation about her kids being loud in the hallway, but other than that, that's between management. We don't have an on-site manager at the time. We have a part-time one, and they're well aware of these incidents as well as the false allegations. But other than that, I feel very unsafe in my apartment, even though I've been there for 6 months. She's shown a severe pattern of harassing others, not just me, and this has been retaliation. The PPO was filed after I told Chief about her behavior. And the reason why I didn't bring it to Chief's attention in June, the end of our friendship, because it was the end of a friendship. It's drama. Integrity and means a lot to me, and I brought my children to the community of saving to raise them there, not to raise them around chaos and disability discrimination and firearm concerns, accusing me of using drugs. It just goes on and on. We could be here all day if I sat here and read everything that she has said against me, but there's no police reports. Just one about me yelling at her in the hallway of our apartment complex. All these other police reports with everybody else, all the other tenants, prior and current.
At the conclusion of a hearing requesting a personal protection order, the court has to state the reasons for either granting or denying the personal protection order request. That's pursuant to MCR 3.705 as well as MCL 600.2950(7). Also, if the petitioner is requesting a non-domestic stalking personal protection order, the court has again state the reasons why, either granting or denying. And that's what the court is doing here. The initial petition was requested ex parte. The court denied that based upon the information that was contained within the petition being insufficient. In this case, we have a relationship, a friendship apparently that broke off either in May or June of 2025. And essentially the relationship went off the rails. According to the petitioner, it was constant harassment, posting of messages, etc. on Facebook, contact in the hallway, etc. All these activities allegedly going on. Further, the petitioner is claiming that messages have been posted since then, which she believes to be, again, reason for a non-domestic stalking personal protection order. The respondent, on the other hand, states in part that the petition, strike that, not the petition, but the friendship broke off again in May or June of 2025. And since then, there have been ongoing issues in the apartment complex, potentially loud noises, children playing in the hallway, whatever the situation may be. But she states under oath as well, as a petitioner with completely opposite evidence, testimony, that she's not posting anything. I inquired of the petitioner regarding whether names were specifically posted of individuals, of the petitioner, stated by a respondent that something was going on here. And there are none, but you also have to think about, well, is there something else going on here that's a problem? And there are even allegations now of, for instance, someone carrying a firearm, displaying a firearm, which at a minimum, the court can take judicial notice, at a minimum would be at least felonious assault, potentially a 4-year felony, unlawful display of a firearm. I mean, these are serious allegations. These are criminal allegations. Police were not contacted. However, Department of Health and Human Services apparently was contacted. And there's nothing in the record to indicate to the court whether or not anything was followed up with that investigation or not. The court, on its own initiative, sua sponte, had called Chief Repke, Stephen Repke of the Sebring Police Department. I saw him in the courtroom. Actually, when the case was called, I saw him stand up, and which drew my attention to him as well. And so I'm trying to find out what indeed is going on here. That's what all the court's trying to do. And the reason for the court doing that is, at least from my experience, when it comes to law enforcement, the purpose of a police agency is to protect and to serve, number one. Number two, they're to investigate criminal complaints, request arrest warrants, file charges, etc. That's their job. And Chief Repke had taken the witness stand. And I had asked him regarding what may be going on. And what it sounds like is just constant calls, countless, I think was his word specifically, countless calls coming in to the Seaboing Police Department, not only himself, but his other officers, regarding disputes or issues going on inside this apartment complex. Even issues where someone's parking in the wrong parking spot or trivial matters like that. May not be trivial to those who are at the apartment, but it's trivial, generally speaking, because we're talking about non-domestic stalking. We're talking repeated contact where there are threats involved. And what the court heard was basically what I find, based upon the testimony, simply a relationship that's gone bad and toxic to the point where, as soon as this court finds that if the respondent is even around the petitioner, and I can't help the fact they live in the same apartment complex, it brings up all these bad feelings and all these allegations are made. And I mean, it's just thick as thick can be here regarding what's going on or what's alleged to be going on here. To add fuel to the fire, I get a response from the respondent who's testified under oath that the petitioner, though she may be afraid that she's being stalked, posting messages on the respondent's apartment door. That's what she testified under oath. I allow final argument to allow the parties to raise their points, and then the court can make a decision based upon having all the knowledge here. Not once did I hear in the petitioner's prayer for relief and or final argument to say, that's not true, that didn't happen. So it's uncontroverted that petitioner is putting things on the respondent's door. And I know for the record, the petitioner shaking her head, but there's nothing in the record indicating that that was not done. So it begs the question, why in the world would someone need a personal protection order based upon alleged stalking when, one, the individual is not referenced in any Facebook messages, second, the respondent denies them that there were posts, but more importantly, the petitioner continues to go to the respondent and put items on the door. Why in the world would you do that if you were afraid or you were stalked? There is absolutely no evidence in this case for personal protection. Personal protection order request is respectfully denied. That is all. Off the record.
Wow. He honestly, he got to the end of that a lot faster than I expected, than I remembered him getting to it. I'm not even sitting properly here to even talk to you guys. Oh my gosh. What do I do? What's going on? I gotta look at something before I switch screens here. Ladies and gentlemen, we had two amazing donators tonight. Charlene, thank you so very much. Scott, Josh, thank you so very much, both of you. Oh my God. You know how I don't really like, pausing the videos. It's just not my style. I every once in a while I was doing the Colin pause. Oh God, I'm doing that thing again. Hold on, let me get my mic fixed and turn the volume down. There we go. Yeah, I was doing the Colin pause there for a while, and even that. I don't know, man. I like when I'm watching it back myself, I like to not have a break. That's just all there is to it. It's a me thing. I'm weird like that. It's the archivist in me. In my brain, we're doing this for archival purposes because these things are valuable to archive and have available to view for various purposes. Most of them educational. Tonight, ladies and gentlemen, we saw a lot of stuff, a lot of follow-ups actually. Bring us right back around to the place we need to be. Some conclusions on some long cases. A young lady in Michigan that has been dragging the Anderson issue. It's finally over. She worked her final good graces with the judge. He finally said, no tribal issue. And the young lady who kicked the cop in the nads, she's going to be spending the next 4 years in prison. Because she just couldn't act right. Ladies and gentlemen, act right. Be kind to your neighbors. And come by tomorrow at 11 a.m. because I have a huge show planned. I don't have it cut yet, but I do have it planned. I'll tell you a little bit about it. I think, maybe, possibly, I'm opening these things up. See, I've got one that says Stewart. Okay, no, got a real interesting one with Judge Gautier. It's not coming out tomorrow, but it is a solar farm battle. I don't know if these things are things that interest you, but it's kind of social issue. I thought the case was really interesting. It's a longer case. I don't know if I'm actually going to show that tomorrow. But I got Mogan upset lawyers. I got Santo gelling guys. I got Santo gelling girls. I've got Crumb angry at somebody for some reason. McNally doing something with an auto sales place or something. I don't name these things very well. I'm starting to realize I don't name these things well at all. Anyway, there's even a self-sit with Judge Webster in here that is 1 hour and 30 minutes long by itself, kids. Come on by tomorrow. We'll see what we're gonna watch. I'll see you then. Till then, I'm out. Oh yeah, that's 11:30 a.m. No, 11 a.m. Not 11:30. 11 a.m. Wait, just let me come back. Just horrible timing. It's 11 a.m. noon Eastern. Is when we do the brunch. So, please come by. It's only like 13 or 14 hours away, something like that. Oh God, kids, whatever you do, always give 100%. Yeah? Unless you're donating blood, then not so much. Y'all have a good night.